10 degrees below, the Arctic coast of Norway. The ruins of a monastery, the holy temple of Preavia, thousands of miles away by the border between Cambodia and Thailand. What have they got to do with each other, or with a peaceful frontier village between Belgium and Holland? Well, the lives of people in all these three places have been affected by law, international law. Where they live, or worship, or earn their livelihood. These simple facts have all, in recent years, been the subject of cases before the International Court of Justice at The Hague in Holland. The International Court of Justice, the World Court, the supreme judicial organ created by the United Nations Charter, to bring about by peaceful means the settlement of international disputes which might lead to a breach of the peace. At the Peace Palace, 15 judges from as many countries. The President arrives for another day's hearing. The court over which he presides has been called the highest point man has ever reached in his social relations with other men. Judges from the East, judges from the West. None is a representative of his own country, nor of his government. Each must declare that he'll exercise his powers impartially and conscientiously. Yet the justice he dispenses is only for those who accept it. The court's jurisdiction depends upon the consent of the states concerned. May the sun of justice shine upon us. Many are those from many lands who, in the last half-century, have trodden these halls in search of justice. The marble of the corridors echoes with man's age-old struggle to replace the argument of force with the force of argument. On a site given by the Netherlands government, the Peace Palace was planned. A Mr. Andrew Carnegie, American industrialist, gave $1.5 million towards the cost of its construction. Inside it, the world's monumental library of law. These walls have heard the argument of the most able lawyers from all over the globe.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially.
First, the dignity of the law, the gowns and jabots of justice. The agents, representing the countries in the case, take their places. Only states may bring cases to this court, not individuals. But there's no reason why a state cannot adopt the cause of one of its nationals and bring a case against another state. A judge is elected by the United Nations General Assembly and the Security Council for a term of 9 years. His term may be renewed, and every 3 years the terms of 5 of the 15 judges run out.
La Cour.
The judges take their places according first to seniority as international judges, and then age. The vice president sits on the president's right, the senior judge on his left, and the next senior judge on the vice president's right, and so on. All have achieved the highest distinctions in their countries as judges, statesmen, legal advisors, and teachers of law. The judges elect their president and their vice president. None of them can be dismissed except by the unanimous consent of the others, a protection against political pressures.
L'audience est ouverte. The hearing is open. La Cour se réunit aujourd'hui pour examiner le différend.
Any legal dispute between states may be referred to the court by the parties concerned.
La République sud-africaine de
Acceptance of the court's jurisdiction is voluntary, but a number of states, sometimes with reservations, have freely recognized the jurisdiction as compulsory. Since 1946, many important cases have been brought. The Anglo-Iranian oil case, the Corfu Channel case, right of passage over Indian territory, the Minquier and Écrou case, the asylum case, and many others. He who is commonly regarded as the father of international law, Hugo Grotius, was born in 1583 in Holland. He followed earlier writers such as the Spaniard, Vitoria. Grotius was a lawyer, historian, poet, theologian, and part of an era rich in new thought and ideas. He was the first to define international law. After a political quarrel, he was jailed for more than 2 years, finally escaping in a box said to contain books. He wrote extensively on natural law and public law, on justice as part of the social nature of man, on the territory of a state, and how the high seas belong to all. Yet 150 years were to pass after the death of Grotius before there came this first vital development of a world law. In the Jay Treaty of 1794, between Britain and the United States, the principle of the settlement of international disputes by an impartial body was accepted. After another 80 years, in a room in Geneva, the Alabama room, the same two countries referred a dispute to arbitrators. The United States asked compensation for the toll of shipping taken during the Civil War by a raiding ship called the Alabama, built in Britain. The claim was upheld and settled by a check. Follow the signposts of history to 1899, the first peace conference at The Hague. The nations, represented by a score of crowned heads of Europe, took a major step towards the peaceful settlement of international disputes. They created the Permanent Court of Arbitration. From now on, any two disputing states could each choose one or more arbitrators from a list of some 200 names and put their arguments to them. This court remains in existence today. In this room, in the Peace Palace, the diplomatic representatives of the signatory powers hold their administrative meetings. Each chair is emblazoned with the country's national crest. In 1920, a really decisive advance, the creation of the Permanent Court of International Justice. Now, for disputes between states, instead of a list of names, a genuine permanent tribunal, a court to which a case could be referred without, as with the Court of Arbitration, a special agreement between the two nations in dispute, but merely on the application of one of them. And then, war. Neither the court, nor the League of Nations, nor any other development of man's wisdom could prevent it. 1945, and the World Court returned to the Peace Palace, this time as the International Court of Justice under the United Nations Charter. The International Court became the principal judicial organ of the United Nations. It's one of the 6 main organs, with the General Assembly, the Security Council, the Trusteeship Council, Economic and Social Council, and the Secretariat. Each member of the United Nations, and every other state to which the court is open, undertake to comply with its decisions in any case to which they may be parties. And, under the Charter, the Security Council can take action to enforce a judgment. At the United Nations in New York, judges are chosen in separate and simultaneous elections in the Security Council and the General Assembly.
Peru, Philippines, Poland.
Not more than 1 judge from each country, and the selection also takes into account the need to have the main currents of civilization and the main legal systems of the world represented on the bench.
The result of the election, voting in the election of 5 members of the International Court of Justice is as follows.
Let us see how a case comes before the court. First, an application is filed with the registrar. The other party to the dispute is informed, and it names its representative. He's called an agent. Before the court opens, written pleadings, sometimes very voluminous, are filed. Cases refer to an event or an incident which may have taken place at any point on the world map. Latitude 70 degrees north, the Norwegian Arctic coast. The case involved Norway's rock rampart, a zone some 1,500 kilometers long. After fishing this area for centuries, British fishermen withdrew early in the 17th century and didn't come back for 300 years. And then the red ensign reappeared. Norway set limits in which foreigners were prohibited from fishing, and in 1935 made them official by national decree. In 1948 and 1949, a number of British trawlers were arrested. Britain took the case to the court, claiming that the area was the high seas. She acknowledged the 4-mile coastal water limit claimed by Norway, but she questioned whether the baselines used to determine this limit were legal. The baseline, she claimed, should be the low water mark. The main issue became the method of measurement along a rugged coast like this, with its rock rampart stretching far out into the sea. Latitude 15 degrees north, far across the world, in the temple of Preah Cambodia brought this case, claiming that since 1949, Thailand had occupied part of her territory on which the temple stood, a sacred place of pilgrimage and worship for Cambodians. She claimed that since 1954, Thailand had stationed troops there. In 1958, the 2 countries broke off diplomatic relations. In the court, the main point was the validity of a frontier line as shown on a map drawn by the French after a survey by a Franco-Siamese mixed commission. Thailand had not for many years disputed this map. An earlier treaty, however, provided that the frontier should follow the watershed. Thailand, however, contended that the true watershed line put the temple in Thailand. Back on a European billiard table, this line is neither a parallel nor a meridian. It's a frontier. Your white is in Belgium, and you cannon off the red into Holland. A game, an inn, a village, a whole district is divided. The National Archives of Belgium and Holland disagree on which of the 2 countries it belongs to. Now, billiards is one thing, but when people built a casino and began playing other more lucrative games which were illegal in Holland, then it was time to ask the court to decide where the actual frontier lay.
alterations just made and declare them duly installed as judges ad hoc for the purposes of the present case.
Since 1946, more than 50 cases of vastly differing character have been taken to The Hague. The court can truly be described as a world court, since it's open not only to all members of the United Nations, but to non-member states who become parties to its statute, and to any other state which declares it will accept the obligations involved. Some say it's not used enough. Some countries accept its jurisdiction in principle, but less so in practice. Some regret that international justice is optional in contrast to national justice. The court also has the power to give advisory opinions. That means, in effect, that it can give its view on legal questions at the request of the United Nations General Assembly, the Security Council, or other authorized bodies. In 1961, the General Assembly sought an opinion on whether certain expenditures, authorized by resolutions of the General Assembly, which were concerned with operations in the Congo and in the Middle East, were expenses of the organization within the meaning of the Charter, which provides that such expenses are to be borne by the members as apportioned by the General Assembly. The court gave its opinion that the Charter did not differentiate between an administrative and an operational budget used for the maintenance of peace and security. And by a majority of 9 to 5, the court was of the view that the costs of financing the operations fell within the category of expenses of the organization. The court has also advised, for instance, on the admission of new member states to the United Nations, the interpretation of certain peace treaties, and on the international status of territories such as Southwest Africa.
Ce jour-là, il y a donc 40 ans, dans cette même
The longer the court exists and the more cases it handles, the greater the body of international law it builds up. Counsel appearing for states may argue for more than a month, with every spoken word recorded. One-day speeches may run to 50 pages of typescript, sent out at night for the judges to refer to. Before the hearing, the pleadings of the parties must be studied, and they can run to several thousand pages, more reading than there is in 10 long novels. In this world of words, they burn the midnight oil. One more judgment is handed down, and the seal of the court is set on one more episode in man's search for a world rule of law. The court has reached its decision on the basis of international conventions and custom, the general principles of law, the judicial decisions and teachings of the various nations. In the case of the frontier land between Belgium and Holland, the court found that the disputed area belonged to Belgium. In the case of the Asian temple, the court ruled by 9 votes to 3 that it was in Cambodia and that Thailand should withdraw any forces stationed there. In the fisheries case, it judged that the fishing limits fixed by Norway and the methods of drawing them up were not contrary to international law. The cases come, are debated, decided upon, an opinion, a judgment given. As the international community grows together in its wisdom and experience, the lights of the International Court can shine as a beacon to lead mankind away from the annihilating peril of war towards a surer peace.